1.
Good morning, and thank you for joining us on this webinar today. We've had really good registration. We've had over 500 people register for the webinar today. So it promises to be really interesting and very insightful. And of course, we have all of these subject matter experts who are seated with us today for the webinar. Who are seated with us today for the webinar. And it's a pleasure to have you all here with us today. So thank you again, and thank you to everyone. I will be introducing our panelists shortly. And of course, none other than our host, Mr. Leye Adebi of Anderson, as the country managing partner at Anderson Tax, Nigeria. He's also the co-chairman of the African Regional Board for Africa, for Anderson Global. So thank you very much, Mr. Adebi, for joining us here today. Next up, we have Otumba Femi Pedro, who is another gentleman who needs no introduction. Mr. Pedro is the current chairman of the Small and Medium Enterprise Development Agency of Nigeria, SMEDEN as we know it, which is the federal government apex agency for small and medium enterprise sector. And of course, we know he was one of the co-founders of Guarantee Trust Bank. But I think most important to highlight today is that Otumba, as we call him, has recently authored the book called The Formula for Wealth, which leverages on his personal experiences on the fundamentals of wealth creation through entrepreneurship, investing, and leadership. So the Formula for Wealth educates readers, right, on fascinating concepts of the poverty trap, money illusion, and the foundational principles of wealth creation. The book is very essential for anyone who desires to create real wealth. And we thought it would be very relevant on this webinar here today because, I mean, if he knows the Formula for Wealth, it will know how the CAMA, right, will impact or, impede that. So thank you very much for joining us here. Next up, we have none other than my partner, Babajimi Ayorinde of TNP. He heads the Dispute Resolution Practice and the FinTech Group. He's a fellow of the Chartered Institute of Arbitrators. He's been ranked by Chambers and Partners as one of the 2 leading individuals in the FinTech industry in Nigeria. Babajimi has a wealth of experience in dispute resolution, and on our panel here today, he will be talking to us about some of the things that we do not see yet. As you know, litigators and arbitrators have a way of looking into the future. So thank you, Babajimi, for joining us here today. We also have Abibat Adeniran, the head of legal and compliance at Global Accelerex, a leading provider of electronic payment and financial technology solutions in Nigeria. Prior to this, Abibat has advised a number of foreign and Nigerian clients, right, on a variety of projects in Nigeria. Thank you very much, Abibat. It's a pleasure to have you here with us this morning. Next up, we have Latif Surakatu, who is a partner and head of accounting services at Anderson Tax in Nigeria. He has about 15 years of experience, right, in the provision of accounting advisory services, and of course, financial reporting services. So thank you very much, Latif, for joining us. Latif will be talking to us today about accounting and how it works in line with the CAMA. And the last but not the least is the most important man on this panel today because he's the representative of the regulator, the Corporate Affairs Commission. So we have Mr. Justin India here with us this morning. He's a director with the Corporate Affairs Commission, and he's graciously joined us, right, to represent the Registrar General on this webinar today. Thank you again, Mr. Justin India, for joining us on the webinar today. And of course, my name is Bukola Bankole. I will be your moderator for the session today. I'm a partner at TNP and Anderson collaborating firm in Nigeria. So again, I'm one of the hosts. So thank you for joining us, and we will go on to the matter for today. So today we will be discussing the CAMA, the new CAMA, and of course, the key updates in this CAMA and the implications for the Nigerian business climate. As we know, we have been saddled with a law which has been decades old, right? Before a number of people were born, and people who are actively, who are impacted, and continue to be impacted, by this law that we talk about here today. So it's actually quite an interesting one, right? Because this law was, modeled after the English Companies Act, which has had several iterations. But of course, we have to wait here and be working with a law that was decades old. And from a business perspective, various people and businesses did have to suffer, going through a lot of concerns under the old CAMA, from the need to have a second shareholder or to have a second director. And believe me, the reason for that, I doubt anyone can remember. So here we are today, and I guess wisdom, time, providence has come to play. The current government has now enacted the new CAMA. So we will be talking about the new legislation today, its implications as it affects our businesses and our lives. So without further ado, I think I will go into the questions for today, directed at our panelists. And first up is none other than Mr. Adebi. Thank you very much again, Mr. Adebi. And I trust you can hear me clearly. So I think the biggest thing that's been touted about this act is the ease that it is brought to small companies and small businesses. But if you look at it, the old CAMA did deal with small businesses, and the definition of, a small company under the old CAMA was qualified by a certain financial threshold. Now, when you think about the implication of the new definition of small companies under the CAMA 2020, the financial threshold, to qualify for that is having a turnover of not more than 120 million naira. Whereas under the Finance Act, which is another act, right, which is very relevant, it's a gross turnover of not less than 25 million naira. So, do you think there is a need to harmonize both of these laws?
Thank you. Thank you very much, everyone, for joining this webinar, and thank you, Bukola, and the other members of the panel. I think we need to step back a little. We need to remember that in 2016, the federal government set up the PEBEC, that the Presidential Enabling Business Environment Council, to kind of work with professionals, and I was a member of the MBA committee that worked with PEBEC in addressing some of the shortfall in provision of Nigerian law affecting ease of doing business. So one of the main criteria given to that council was for the council to, first of all, work on improving the ranking of Nigerian in the World Bank ranking of doing business, and second one was to remove any impediments to doing business. So Nigeria always talk about the informal sector, and we say that the informal sector, there is more money in the informal sector than the formal sector, which is one of the bases for the enactment of this law, to bring more of people on the informal sector to the formal sector. So, and the issue then was how do we define a small company? A small company was defined under CAMA as one having not more than 120 million in turnover. As you rightly pointed out, if you look at the Finance Act, a small company for company tax purposes is one with a turnover of no more than 25 million. So if you compare the two, in the threshold for CAMA, there are three categories of companies for tax purposes. The first one is those with 25 million turnover that say is free from paying any taxes. And the second one is those between 25 and 100, that is fine as medium company that pay 20% tax, and then anybody above 100 million turnover pay 30% tax. So if CAMA is going to define a small company as 120 million, then there is already a disalignment with provision of Company Income Tax Act on tax obligations. So for me, that is one of the first area we need to find an alignment. How do we define small company in CETA that's going to align with definition of small company in CAMA? But I know FRS will not want a situation where you define small company with minimum of 120 ton as has been exempted. There is no way I think FRS is going to agree to that. But so maybe our director from CAC will let us know if CAC will agree to move back to the CETA provision of 25 million. Otherwise, not only this provision, there will be other provisions in the CETA that are going to cause disalignment in the operation of company. I can always tell you I'm a small company because CAMA is designated as a small company. But FRA is saying you are not a small company for our purpose because you have a turnover of 120 million. You have to be paying tax at 30%. But my definition of small company is that I should be exempted from tax because that's what government expected. So, which is why I'm saying the next work for the committee may now be to see how to align this provision of the law in CAMA, the provision of CAMA, to the one in CETA to ensure that small companies mean the same thing in the two law. That's my position.
Thank you very much. That is very correct. Perhaps it's one of the issues will be taken up under the omnibus bill, but that's not what we're discussing now. We'll come back to that issue later. Otumba, picking up on what Mr. Davey has just discussed with us, right? I think what will even be more relevant to you is not even so much so this discrepancy. I think it would likely be on the fact that under the old CAMA, right, the threshold to qualify as a small company was not more than 2 million naira and net asset value, right, not more than 1 million naira. 120 million and 60 million naira respectively. How will this redefinition be beneficial to SMEs? And how do you think the revenue threshold affect the corporate governance expectations for growing small companies that typically approach your organization for support?
It's muted.
The definition of small businesses under CAMA and under CETA is completely different from the way we see it in the MSME space. We have a subdivision of small businesses. We have micro small businesses, and they are the large majority. In fact, when you talk about the informal sector, you are referring to micro businesses. Today in Nigeria, we have over 25 million micro businesses in Nigeria, according to the according to statistics and survey that we have. And majority of them have turnover less than 20 million naira. And those are the ones that we spend considerable amount of time on because they constitute a large portion of job creation in Nigeria. Imagine if one micro business hires 2 persons and we have about 20 million of them in Nigeria. We're talking about 25 million. I mean, we're talking about over 50 million new jobs being created. And the purpose for which SMEDAN was set up mainly order to register. As far as they are concerned, it's too expensive. It's too complex. And the newcomer has gone very far to make it a lot easier for them to register. The fact that you have a provision that allows one person to be the shareholder of a company makes it a lot easier for them, because many of them are one-person businesses, and so that makes it a lot easier. And the fact that even the stricter definition of 20%, I mean, the stricter definition of those with 25 million naira turnover or less pays no tax is good enough for them, because majority of them fall into this category, the micro businesses. So as far as I'm concerned, the new CAMA has come a long way to make ease of doing business much easier for micro businesses, which is the main focus of SMEDA.
Thank you very much, Otumba. That was really helpful. And I think what I've taken from that, for those of you joining us today, is whatever category your business is, you should approach SMEDA, because they have, how to fit you into the bucket. So there's an opportunity with SMEDA, people. Don't shy away from it. Thank you again. So I'm going to quickly go to you, Latif, right? And is to focus on something significant that has been introduced by the CAMA 2020. This act now imposes an obligation on holders of substantial shares, right, and beneficial shareholders in private and public companies to disclose the particulars of their shareholding, right? And they're also, in turn, the companies required to inform the CAC of this disclosure. What will be the implication of this disclosure requirement for shareholders, companies, and investors? Is the very essence of, the ultimate beneficial shareholder, in fact, not to, make this public information? Let's have your thoughts with it. Your mic is muted.
Okay, thank you very much for having me, Bukola. Yeah, the Act actually imposes an obligation on the holders of substantial shares. Basically, this particular obligation is to ensure that there is transparency and also prevent asset shielding. And of course, we all know that investors' confidence in financial markets is dependent on the accurate disclosure of financial, information and data, especially looking at the ownership and control structures. So this is what this particular requirement is attempting to do. But basically, it's not a new requirement. Even under the old CAMA, this is a major requirement. Of course, the threshold over years has changed. At some point, it was 10%, but the new CAMA introduced 5% unrestricted voting right for this to be disclosed. And in time past, if you look at the implementation of this particular requirement, it may be pretty sometimes very difficult to really guard against what the requirement is looking into. One of such is that companies have attempted and shareholders have attempted to have a complex structure for ownership of shares, such as when you have omnibus shareholding through pension fund, through mutual fund. And if you look at this, it then means that it may not be very easy for investors to truly know who are truly behind the ownership of these shares. So in terms of implementation, it may be pretty difficult. But let's see how this goes. In terms of compliance. Another area that it could be very difficult to even ensure full compliance with this requirement is when you have nominee shareholders. We've had several cases of this, and you may not be very sure who is really behind these shareholdings. This could come in a very complex way. But by and large, what this requirement speaks to is that it's giving investors some level of confidence. Disclosures has to be made even beyond CAC filing. For the audited financial statement, there's a particular requirement which auditors will always look into, which is disclosing share ownership, especially the significant controls and what have you. I think this is a very good requirement, which we need to ensure that the full implementation is done.
Thank you, Latif. You're correct, and we do agree with you. Transparency, amongst other things, are some of the reasons why this is now very key. And of course, with the way the world is evolving, we know all of the AML compliance requirements, like for global standards. So this is very relevant. However, I think something that is also relevant is, given that this information will now be provided to the CAC and will be made available to the public, there are concerns, right, about the data protection issues that could arise from this. And I think we'll be looking to the regulator to see how they will solve that, right? I think some of the things, we, the public and stakeholders, are looking to is to see how the CAC will in fact implement this. And I think we'll be talking to Mr. Justin at some point, if we can sneak that question in, around how they intend to protect that top, to ensure that, unique identifiers, are not, made public information. But thank you again. And now to Baba Jimmy. I know we have some lawyers here with us, so it will be good for you to address some of their concerns. Baba Jimmy, Section 705 of the new CAMA prescribes 4 conditions for qualifying as an insolvency practitioner. Now, the 4 conditions appear to be conjunctive, right? Such that where any condition is not satisfied, a person cannot and will not qualify to act as an insolvency practitioner. So how does this affect insolvency practice in Nigeria? Would you say it's necessary to have the 4 requirements, or what's your take on this?
Okay, thank you very much, Bukola. Yes, you're right that those 4 conditions are cumulative, meaning that anybody that wants to practice as an insolvency practitioner under the new CAMA must meet each of those 4 requirements. But I must quickly add that there's nothing particularly unusual about this. For laws always reserve certain roles for members of certain professions or people with specific qualifications. So that in itself is not new. The insolvency provisions that we have in the new CAMA are actually taken from the UK's Insolvency Act of 1986. And Section 392 of that act actually states that you can only practice as an insolvency practitioner if you are qualified. So it says only qualified people can act as insolvency practitioners. And in order for that to happen, you need to belong to certain types of bodies. I know a lot of noise has been made about the specific reference to BRIPAN in the new CAMA. But once again, I know this is unusual, but it's not totally unheard of. I mean, my own profession, the legal profession, has benefited from this. The Legal Practitioners Act specifically mentions the Nigerian Bar Association and reserves certain roles, certain activities for lawyers. I think what is important is that same section, or that same subsection that refers to BRIPAN, also creates an opening. It allows the CAC to recognize other professional bodies whose members can practice as insolvency practitioners. So I think what other professional bodies like the NBA and ICANN should do is to get CAC to recognize their members as insolvency practitioners so that they could also take part. Now, you asked the question about whether I thought those 4 conditions were necessary. I think my biggest problem with those 4 conditions is the first one, which seems to require that for someone to practice as an insolvency practitioner, you need to have a degree. I think it's about time we actually start de-emphasizing paper qualifications and degrees and focus more on competence, right, and the capacity to carry out certain roles. Like I said, some of these provisions were copied from the UK, but I noticed that they don't have that provision about degrees, right? What they are more concerned about is whether or not you have the ability to perform the role. So I think it's a good development. I don't see anything wrong with CAMA specifying minimum requirements for carrying out these roles. And I think that other professional bodies can take advantage of this provision. Thank you. Bukola, you're muted.
That was really helpful. And I will go to Mr. Justin in there, our regulator. Given that this section makes it a condition for insolvency practitioners to obtain an authorization form from the CAC before acting as such, has the Commission started granting this authorization? I mean, where exactly, is the CAC with it today? If not, can a person be appointed a liquidator today without obtaining this authorization? Please tell us where the Commission is at.
Well, let me say from the outset that the Act has not yet come into force because it has not been gazetted. So specifically what that means is that the Commission cannot start accrediting members of recognized profession for the purpose of practice of insolvency practitioners until and unless the Act comes into effect. So that is basically what the position is. But as soon as the Act is gazetted, the Commission will put mechanism in place for accreditation of insolvency practitioners. But it is already developing a framework for recognition of professionals that will be qualified, whose members will be qualified to apply as insolvency practitioners. Okay, that's all I want to say on that.
Thank you very much, Mr. Ndia. And let me stay with you for 1 minute real quickly. The question that has been asked of the CAC at a lot of forums very recently is, where exactly are we, with the gazetting of this new CAMA? I mean, surely it's been a couple of weeks now. And the public is also looking to you, right? When can people see a copy of this new, of this new CAMA? As the regulator, are you guys going to share with us or have somewhere on your website, something that the people can see? There are several versions, flying all over the place. And we are all discussing this thing that we're saying has not been gazetted. So where exactly are we, Mr. Justin?
Well, the responsibility for gazetting the Act is actually that of the National Assembly. But the Commission is working closely with the National Assembly to ensure that that is done as soon as practicable. So what we are hoping that maybe before this month ends, at least the Gazette should have been out for members of the public to assess the correct version of what Mr. President signed into law.
Thank you, thank you, thank you. Hopefully, by the time we see that gazetted version, all of these sections will be referred to today. They will be correct. So thank you. Okay, Abibat, let me come to you real. Considering the compliance obligations under the old CAMA, and with the new CAMA, when you take them side by side, will you say that the new CAMA is more progressive? I mean, what do you see as head of legal and compliance? What would you say?
Thank you very much, Bukola. Definitely, I would say it's more progressive, yes, especially when compared with the provisions of the old Act. The new CAMA is materially more progressive and forward-looking than its predecessor. The Act relaxes old compliance provisions, in most cases, it seeks to make compliance easier and more efficient, thereby increasing the ease of doing business in Nigeria. There are several provisions in the new act that speak to this, ranging from the single membership requirement, the exemption of small companies from certain compliance requirements, such as the need to file and the need to audit accounts, the need to hold annual general meetings, and so many other things. Also, the recognition of the validity of virtual annual general meetings is also something that is quite progressive, especially given the fact that we're in this COVID era, and there is a general restriction on convening physical meetings. Also, the recognition of electronic signatures for signing of documents, signing of share transfer forms will also be very helpful. So, in a nutshell, yes, compliance requirements are definitely more progressive, and the act. It's a good thing that the act has finally caught up, with current global best practices. Thank you.
Thank you. Thank you, Abibat. For in-house counsels that have joined us on this webinar today, can you, dig in deeper and tell us what changes and obligations would you specifically be advising in-house counsels to look out for?
Thank you again, Bukola. I would like to say first and foremost that all compliance requirements are essential, especially given the fact that the new act grants the Commission very wide discretionary powers in determining the quantum of penalties for infractions under the act. So again, to just emphasize, all compliance requirements are essential, but then there are a few that we should look out for, particularly because these provisions have been in the past overlooked. They are easily overlooked, such as the requirement to keep statutory registers. The new act allows for the electronic keeping of these registers, so compliance should definitely be easier at this point. There are also new books that the new act introduced, such as the Register of Directors' Residential Addresses, the Register of Secretaries as well. So these are things that we should look out for, particularly because, again, the penalties imposed under the old act were very meager. I think it was 25 naira per day. And right now, we do not know how much the Commission will slam on a company for non-compliance with this requirement. Also, in-house counsel to public companies, there are certain provisions in the new act that relate specifically to public companies that in-house counsel needs to pay particular attention to, such as the requirement to grant notices to the Commission for their meetings, the requirement to, again, the restriction against multiple directorship. Right now, a person cannot be a director in more than 5 public companies. There is also the requirement to have 3 independent directors on the board of public companies. Also, the Act imposes stricter and additional obligations on the directors of both public and private companies. It is our role as company secretaries and in-house counsel to educate our directors on these stricter obligations and the stricter consequences attached to non-compliance. Then again, there is finally the requirement to file annual returns, which hasn't really changed. It's still 42 days after the AGM. But in the past, you will notice that typically we do not pay that much attention to this provision. Again, these are things that are very easily that you can easily comply with. So there is really no reason not to pay attention to them. Thank you, Kola. Oh, sorry, and I forgot there is one very important thing that I left out. That's the disclosure of beneficial ownership requirement that you've already, that some of the panelists have already touched on. Thank you.
Thank you very much, Abiba. Otumba, Abiba has touched on something that is very relevant to the sector that you overlook. The CAMA prescribes penalties, to offenses, a variety of offenses, right? And some of that is carrying on business without registration. What's the likely implication of this provision on individuals operating in the informal sector? Otumba, I think your mic is muted.
Sorry. Yes, thank you very much for having me. I said earlier on that the majority of businesses in Nigeria operate informally. They are not even the point of penalizing them is neither here nor there. It is when you know somebody that you are able to impose penalties. So what we are doing now, our major focus as MEDAN is to bring these informal businesses into the formal sector. That is, get them registered CAC. With this new CAMA, it has made our work a lot easier. The first step we are undertaking now, and I'm saying this for the benefit of everybody listening, is that MEDAN is already in the process of its own mass registration of all small businesses, irrespective of whether they are registered with CAC or not. We're already embarking on that. It's an online process. It takes only 5 minutes. It's free of charge. You go to the website. Agro-allied businesses in Nigeria. How many of them are registered with CAC? How many are not? So once we collate this data, what we are now doing, our next step, we're already talking to CAC, and I'm happy the director is here. We want to do bulk registration. That is, get a large, huge number of these informal businesses, pass their data to operated with very little ASU, and MEDAN will subsidize the pay. Because even if we penalize them now, they will not respond. You can't even hold them down. And there are quite a huge number of them. When you go to the field, you can't believe it. Many of the artisans, many of the traders, even those in the agro-allied businesses, they just don't see any reason why. In fact, they think when you ask them CS registration, they think it's an opportunity to entrap them to pay tax, and they dodge it. So we now want to use the layer of MEDAN, its programs, its facilities and activities to encourage them that if you are not registered with CAC, you are not going to benefit from what right now the federal government is unveiling what we call a survivor fund program this coming week. And what this does is that any company, any business in Nigeria that employs 3 persons or more and was struggled during the pandemic period, during the lockdown period, the federal government will take up responsibility of paying the salaries of its workers for 3 months. During that period, and if you are lucky, you are choosing, you will get paid. And we are telling them that you will not benefit if you are not a registered or an incorporated company. The only thing that saddened me is that really I'm hearing for the first time that the CAMA is here to take effect. I thought that the moment the law was signed by the president, it should have been gazetted within a matter of days, not even weeks. But well, hopefully it will soon be gazetted. That means that all those who are going to apply for this the old CAMA made it virtually impossible for them. First of all, it's too expensive. The requirements are too stringent, and many of them don't even want to have directors. The way they run their business, they are compliance requirements. A major change, and I will be talking more with CAC, so that we can work an arrangement where we can do bulk registration. That's very important for us, and we are ready to pay for it from MEDAN. Thank you.
Sounds like a really fantastic initiative, Otumba, and very well done to you and your team. I would have loved to invite the lawyer, Babajimi, to comment on this whole gazetting issue. But believe me, you don't want the lawyers to get started on this issue. So we will save the time and move on, with our program. But I'll come to you real quickly. Mr. Ndia, there are various, powers for the Commission under the CAMA 2020. You can make regulations, you can impose fines and penalties, and a whole lot of things. As you would have heard from some conversations here already, we are very worried because we don't know what you're going to prescribe. We don't know what's going to be done by the CAC. So can you tell us, when should we expect, your regulations to be out? Is that in the works already? And in addition to that, sorry, before you respond, we also know that there's supposed to be an administrative proceedings committee, with the power, to actually impose administrative penalties. So it would also be good if you can talk to that and tell us, where you're at.
Okay. Thank you very much. Let me first start with the issue of administrative penalties. When you look at the law in itself, there are several sections that empowers the Commission not only to prescribe administrative penalties, but also the fines that will be administered by the court. So as soon as Mr. President gave assent to the act, the Commission constituted what we call an in-house committee to develop regulations that will help to implement the act. And in that regulation, there will be fees, there will be penalties, there will be further regulations on gray areas that we thought are necessary. And then there will also be schedules to guide the members of the public on what is expected of them. The committee, as at today, has finished its work. It will submit it to the chief executive. But the responsibility of enacting the regulation into what we call subsidiary regulation legislation is that of the minister. But the intention of the commission actually is that when these fees, penalties, and regulations are developed, it will be exposed to the members of the public for comments. And when it is done, the commission will be sensitive to the comments that will come from members of the public. It will review the draft that has been exposed to the members of the public in the light of comments that will subsequently come before it forwards its final output to the minister for promulgation into a subsidiary legislation. So that is the position we are today. We, as soon as possible, maybe next week, expose the draft to members of the public. Now, on issue of Administrative Proceedings Committee, or the APC, what we want to say is that it's an attempt by the Act to introduce what we call alternative dispute resolution mechanism into company administration, because over the years it has been found that commercial disputes actually take very long period of time to resolve, and that is not good for those that are into business. So it was thought that there should be an alternative dispute mechanism to reduce the length of time that is taken to resolve commercial dispute. And the members of the panel, 7 of them, are clearly defined by the Act. So the Registrar General chairs that panel. We have 5 additional directors that are in charge of operations. Then there is a representative of the Federal Ministry of Industries, Trade and Investment. So that is the composition of the APC. There is also a provision that where, for instance, a matter is technical, the committee can actually co-opt an observer to advise it on such technical issues. But the statutory members of the committee are 7, and the other things that the commission may require is only to acquire maybe a venue for the committee, which would also require recording facilities, because when you look at the provisions of the Act, it says that the committee needs to procure what we call electronic recording device to take proceedings of the committee. So the commission is working towards acquiring those gadgets that are necessary for the work of the committee. The only other aspect of the secretary, which is required to be a lawyer with 10 years post-call experience, that one is very easy to achieve, because the CAC have over 200 lawyers, and most of them has passed that requirement. So they can easily pick the secretary from the staff of the commission. So we don't have problem with the establishment of the administrative proceedings committee, because the membership are already clearly defined. What we need is just administrative process as soon as the Act comes into effect to kickstart the process. So that, in summary, is the position of the APC. Thank you.
Thank you. It's really good for us to know that. Thank you. So quickly to you, Mr. Devi. Now we know that small companies, right, will be exempted from auditing their accounts. However, under the CETA, although they're exempted from paying companies' income tax, they are required to file their tax returns and audited accounts with the tax authority. So can small companies under the CAMA enjoy this exemption without actually breaching their filing obligations under the CETA?
Thank you very much, Bukola. I think your questions have actually provided the answer itself, because which is what I said earlier, there will be some harmonization between CAMA and CETA. CAMA says if a small company with 1 director and some equity and turnover, then you don't require an auditor. That is to ease doing business. I mean, like Otumba said, some of these companies are informal. They don't know what keeping an account means. So, but by the time you exempt them from having an auditor, but another law that's more important says every company, whether you are exempted from paying taxes, you are required to file your financial statement. Where they didn't say audited account, but the law requires you to, CETA requires you to file your financial statement and your tax returns. Even though you are exempted, you can put 0 tax. So how you are going to do that without having an auditor? Maybe you want to just have an accountant prepare your financial statement, but in a way, however where you are exempted under the CAMA from appointing an auditor, you are not exempted under CETA Section 55 from filing your financial statement and your tax return, even if your turnover is 10 million naira. Don't forget the minimum turnover for a small company maximum is 25 million. You are exempted from paying taxes, yes, but you are not exempted from filing, because the only way FRA will know whether you are exempted or not is when you file your account. If you are 26 million, you are no longer exempted. You are falling to the category of people who pay 20% tax. So there is still a lot of work to be done in this instance, because both people in CAC and people in FRS need to harmonize this provision. Maybe you want to say for company who have 25 million naira turnover, they don't need to file any financial statement, because since you are not required to pay any tax anyway. Then at that point, you can say those people will not require to have auditors. but a blanket exemption from auditor for company with 120 million turnover is going to be hard because, as I mentioned to you earlier, between 25 and 120 million, there are 3 categories of companies under CETA regulation. You, 25 million, you pay 0 tax. 25 to 100, you pay 20%. 100 above, you pay 30%. So CAC cannot just say you don't require to take auditor. Well, I don't expect somebody working, preparing, doing his business in Alaba, doing 120 million turnover every year to file his own statement, prepare his own account himself. He will require to be able to file a statement with FRS and also pay some taxes. You are not exempt from paying taxes as a small company. If your turnover is above 25 million, and even then, like I said, you still require to file a financial statement. So there's still a lot of harmonization that need to be done in this instance. And then Otumba will confirm to you, if you become, Otumba is to be a bank, that's what I'm saying. If I want to go and borrow money from a bank, and I say, okay, I want to borrow money, they will, the first thing they will ask me, I should provide my auditor account, however much I'm borrowing. So even if you're a small company, the law says you don't need an auditor, but for your own interest, I think for you, if you really want to do a proper business, I think you require to have an auditor. But then, as I mentioned before, the essence of this amendment was to ease doing your business, doing your business in Nigeria. So in that regard, then both CAC and FRS still has a lot of work to do. There are still some harmonization that need to be done, whether through PEBEC or intergovernment agencies on how to reconcile some of these conflicts.
Very valid point, Mr. Devi. There is indeed still some work to be done. And of course, we'll be trusting people like yourselves as stakeholders, right, to help engage with, all of these authorities and see how we can work with them, to see how things can be harmonized. So over to you real quickly, Latif. Since you're talking about divergence, so can you tell us, you're the accounting expert, right? Is there any divergence, right? Areas of divergence between the CAMA 2020 and the International Financial Reporting Standards? And if there is any, what's the right course of action, for companies? If you can just talk to us real quickly on that point.
Okay, thank you very much, Bukola. CAMA 2020 attempts to harmonize its requirements on form and content of financial statement with the requirement of IFI, which is the International Financial Reporting Standard, specifically IS1, that talks about the component of financial statements. So one of the new introduction into the CAMA 2020 is the statement of changes in equity, which was never there before now. So that is a change, and I think it is a welcome development. Another important statement that was also introduced was the statement of cash flow. Before now, it was only a statement of source and application of funds that was there in the old CAMA. But with the new CAMA, we have added to it statement of cash flow. But essentially, there are still a number of areas where the new CAMA has not been able to actually harmonize. One of such is the fact that the statement of accounting policies based on International Financial Reporting Standard is actually part of the note to the financial statement. But looking at the CAMA 2020 is a standalone requirement, which is not part of the note. The note to the financial statement is also separated, Then looking at that, the fact that under the International Financial Reporting Standard, value-added statement, which is part of CAMA, is not a requirement of International Financial Reporting Standards, as the case may be. There are still areas for harmonization, but one important thing that is noted under International Financial Reporting Standard, which guides the preparation of financial statement, it recognizes the fact that there are peculiarities around all over the world for the different countries. So whatever the statutory requirement is, in case of CAMA, as stipulated by the Act, is also going to be recognized as part of the audited financial statement, as the case may be. So what that says is that a number of things that are not required by the International Financial Reporting Standard, but are required by CAMA, will still form part of the financial statement of entities that are reporting. So basically, as we used to do under the old CAMA, those requirements, value-added statement, statement of accounting policies, 5-year financial summary, will still be required to be included in the financial statement to be able to comply with the requirement of CAMA, essentially. But one major thing that CAMA also introduced is around the private companies being exempted for some specific accounting requirement. For instance, for private companies, it is not mandatory based on the CAMA 2020 to have disclosed statement of accounting policies, statement of source and application of funds, or cash flow statement. Is also not mandatory for them to also disclose a value-added statement. These are mandatory under IFRS requirement, and I guess for us to have a financial statement that comply with the requirements of IFRS, private entities will be required to have them disclosed, essentially.
Thank you very much, Letty. That's very insightful. Babajimi, let's talk a bit of mergers. Under Section 894 of the copy of the Act that we have seen, we see that it allows associations with similar aims and objectives, right, an object to merge on the terms that will be prescribed by the CAC. In light of, all of the powers of the FCCPC, though, to regulate merger transactions, which body do you think has the power to regulate this merger of associations? Or do you see a way in which, these will be complementary, and what do you see happening?
Okay, so I think there's a misconception about the role and the powers of the Federal Competition Commission. Their role is to regulate competition in markets. Emphasis is on the word markets, right? In fact, Section 2 of the law that sets them up says that the Act does not apply, or the Act only applies to undertakings and commercial activities. It defines undertakings as companies or bodies that engage in trade or production of goods, or companies that provide services. Now, Section 849 of CAMA deals with associations that are not for profit. These associations do not engage in commercial activities, or they should not be engaging in carrying out commercial activities. So it's very, very difficult for me to see how they can come under the purview of the Federal Competition Commission, given that they're not commercial actors in the market. So I really don't see the conflict there. I think CAMA was right to allow the CAC to come up with the terms on which these bodies can merge, and I don't see the conflict with the FCC PC.
Okay, thank you, Babajimi. I think we hear you. Not a problem at all. Let's see how things play out indeed. So I will come back to you, Mr. Debi. If you can quickly talk to, the single directorship. Do you think some SMEs, will change their operating structures from, registered business names to limited liability companies, as the case may be, considering that, we've talked about the exemption they enjoy under the CETA as well?
Thank you very much, Buki. I'm sure it's much easier now for company to move from business name to limited liability company, because now you only require one director and one shareholder to form a small company. Yeah, it is. And I expect more business to become formal, because by the time you have limited liability structure, it's also easier for you to actually bid for some contracts. I mean, I know in the oil and gas industry, you can, the Department of Petroleum Resources, the DPR, will not grant you certain license to bid for some oil contract if you are not limited liability. So there's a category of license you can apply for. So by becoming a corporate body in that sense of being limited liability, then is there more advantage for business name to move into that line? But there have been these questions that people have asked me, that will if somebody now becomes a company now have one single shareholder, does that make it a corporation so as to become liable to personal income tax? I said, no. Having a single shareholder is an exemption granted by the Company and Allied Matters Act. You are still a limited liability company and having right to enjoy all the benefits granted under the law, and also having the rights and benefits granted in order for corporate entity to be able to sue and be sued, I mean, open bank accounts and run your business as a limited liability company. For purpose of taxes, CITA recognizes you as a company, not a business name. Even though it's now one person, but CITA recognizes you under Section 105 as a company, and so you are required to fulfill the obligation of a limited liability company under CITA. But then, as I mentioned, you can fall into three categories. You can either be one of those exempted from income tax if you are below 25 million, or if you are 25 to 100, you pay 20%, above 100, you pay 30. But you are still required to file your return. So you don't pay the tax to Lagos State government just because you move from business name to limited liability company, and you are still the same owner, being a single shareholder. Single shareholder is an exemption granted by CAMA. As a result, you are now a limited liability company for purposes of corporate structure. So I expect more companies to be able to move forward, become corporate entity rather than business name now. So since there are advantages in the corporate structure. Yeah.
Okay, thank you. That's helpful. Now, talking about corporate structures, let's stay with you for a moment, right? The CAMA 2020 now permits limited liability partnerships to be registered, under the CAMA. Does this now imply that limited liability partnerships can be deemed as companies that are taxable under the CITA? You know how our tax people, our tax authority gets. So we want to know, do you think there will be disputes between the FIRS and the state authorities in this regard?
Thank you, Buki. That's actually another very interesting point. Don't forget, you mentioned limited liability partnership. So what we are still looking at is the partnership. That's unlike limited liability company. So this is a limited liability partnership. So an LLP will still be taxed as a partnership. That means the partnership itself is not taxed, it's the partners that will pay personal income taxes to their respective state authorities. So even though limited liability partnership enjoy corporate personality, they can sue and be sued, and can hold property in its name, but that is only for purpose of corporate structure. For tax purposes, that has not changed. The people behind the partnership are who to be taxed. So limited liability partnership only created a structure where some partner will be general partners to run the business, some partner will be limited partners that don't get involved in day-to-day activity. That just to separate that structure. It does not confer corporate personal liability. It doesn't confer corporate liability and corporate personality for tax purposes on limited liability partnership. It still remains a partnership, is LLP, not LLC.
Okay, thank you. And you know, what you're saying is very relevant to one of the questions we got before the webinar today. So I'll just quickly ask those questions and you can chip in one line or two if you just need to buttress any point you've made. So there's a question from there's a question we have, right, that says, can companies come together to operate as limited liability partnerships based on the new CAMA? And what are the tax implications, right, for that arrangement? Also, they want to know if for tax purposes, right, limited liability partnerships, as you know, will be taxed separately from their partners. I mean, as you've already explained, I think that question is answered. So can we go to the first one? Is there anything you want to say to buttress, you know, what you had said earlier?
The companies that have their own separate personality cannot come together to form a partnership for business purposes. I don't see how that will work. They can merge and become a single entity, but they cannot. Partners, companies, it's only individual that can recognize Nigeria to form partnership, because for purpose of personality, that's why you have limited partners and you have general partners. Companies cannot be general partners or limited partners. So it's only individual that can come together to form LLP. So as I also mentioned to have explained earlier, LLP will still be taxed as individual. The individual behind the LLP are the one that will be taxed, which is why companies cannot come together to form LLP, because it defeats the purpose of the taxation structure of it, because they will still be taxed by FRS, and they say their partnership. It won't work that way. That's why they wouldn't be able to come together to form an LLP.
Thank you. And Baba Jimmy, the insolvency practitioners in the house have a question for you. You had indicated earlier that attention should be given to competence over paper qualification. Can you please share your view of how you think competence can be determined in this instance without any reliance on paper qualification? I mean, I can't help you here, so tell us.
So, thanks. So let me start off by saying, I mean, some of the best accountants, right, and tax practitioners I know do not have degrees in accounting or degrees in taxation or anything like that. I think that whilst we want to ensure that certain standards are met, right, in certain areas, I think we should also give room to the fact that there are people who have been, by virtue of their roles, have carried out certain activities and have developed a level of expertise, right, and a level of competence that is probably even higher than people who have degrees in that area. Once again, I'll say the accounting profession is one profession that has done that very well. There are several tracks to becoming an accountant, and I don't know if that has changed, but I know that you didn't have to go to the university to become an accountant. So my own problem with those requirements is that it seems to say you must have a degree from a university or polytechnic, but what if I've gone through some other type of professional training that makes me just as competent? Or what if I've worked in a particular role for the last 25 years that makes me just as competent? So I'm just saying that we shouldn't have a one-track approach that makes it possible for only people with degrees in certain areas to do those things. Yeah.
Okay.
So I hope that answers the question.
Well, yes, to me, but the question came from one of our, attendees. So we hope that answered your question. I'm going to go on and take a few more questions from attendees, and if we have some time, we will ask you some of the other questions we want to ask you panelists. So one question I'm going to ask again is for, it will be for, the question I'm going to ask is going to be for Mr. Justin India. Temi Tokwe Akinyade would like to know, how does CAMA affect companies with one director with 3 other minors? Can the valid director open and run a bank account? I hope you understand the question, Mr. Justin. I think I struggle with it myself, but let's start with you.
I have not gotten the question correctly. What is the issue?
Bukola, you need to mute your microphone.
Thank you. So I think the question, bottom line, is to understand what the treatment, of accompanying with minors, minors on its board will be. And Babajimi, I don't believe that's correct, right? The CAMA still does not permit minors as, directors. But the question again is for Mr. Justin anyway, specific for him, right? Can the valid director open and run a bank account? Mr. Justin, having read this question, I think I can just simply answer for our attendee. And I think the question is, the bank account belongs to the company, right? So it's not about, the director running the bank account, running the account. So it's a company account. So I hope that answers the question for the attendee. There's a question here regarding the benefits due to small companies, right? And the essential thing is we are focused a lot on small companies here, and the larger companies are upset. So they would like to know from you, and I'd like any of the panelists to take the question. What are the benefits of the new CAMA to larger companies? Can you tell us what are those benefits? Abibat, should we start with you?
Thank you, Bukola. I do think that, like you said, we've been focused on small companies because, again, the new act actually eases the compliance requirements for small companies rather than, larger companies. But then there's really some compliance requirements that are targeted at all companies, be it small companies, large companies, or even public and private companies. For instance, we had mentioned the recognition of electronic signatures, which was not, previously, allowed, even though it was allowed under the Evidence Act. Now, the new act has done is to make that recognition more mainstream for, corporate compliance things. And then there's also the recognition of virtual AGMs for private companies. This would apply to a company irrespective of whether it's a small company or a large company, really. And then you can also keep electronic records of your statutory registers, the registers of directors. That applies to everyone, regardless of their size. Yeah. So there are quite a number of compliance requirements that are applicable to company, regardless of its size.
I do agree with you, Abibat. I mean, the virtual meetings is particularly, very relevant, in fact, to larger companies. So thank you for your response. Otumba, I'm coming back to you real quickly because you are the guardian of the SMEs. So there's a question here for you, which is, why are the programs, particularly funding for MSMEs, not done in a transparent manner? Okay. And what is Smeden doing to make all of these information, including details of beneficiaries, available to the public through its website? The call here is for transparency. They want to know that if you're going to be asking people to register and do all of these things, they don't want to, registration will otherwise be viewed as a means of entrapment, right? If they don't have full transparency on the process. Can you quickly comment on that, please?
Yeah, thank you very much. I've been at Smedan for the last 2 years, and I can assure you and members of the public that every aspect of Smedan programs have been transparent. There's transparency, there's accountability. The problem has always been this general cynicism about anything government. A lot of Nigerians are shut off completely. Even when you try to convince them to apply or to register or to participate, they don't believe that it will be done on merit. They don't believe that if they don't know anybody, they can get anything. For instance, the Central Bank of Nigeria, at the beginning of the palliative, at the beginning of the lockdown, started a program of 50 billion naira support fund for MSMEs. And they did it through a microfinance bank, and it was advertised. It was open, and it's still open and transparent. But funny enough, a lot of MSMEs are not even aware that this program is ongoing. As of today, the 50 billion was exhausted. Central Bank has added another 50 billion, 19 billion of that has been exhausted. The program is still ongoing. If you run a small business, go to the website, either our CBN website or the microfinance website, that's the NMFB, Microfinance Bank. You will see the details of the program there. So there's transparency, just that people have to trust government and their program. I don't blame them, because past experiences have shown that many of these programs don't even know how they were applied, how people benefited, how the beneficiaries were chosen. But things are changing. A lot of people who are in government today are quite aware of this problem, and they are tweaking things and making sure that information is dispersed and people are aware. So I can assure you there is more transparency. For instance, this registration program I'm talking about, smedanregister.ng, we've been advertising it, we've been pushing it, but the responses have been very, very slow, because people will tell you, oh, government is using trick to capture my data and my information so that they can come after me to pay taxes. Everybody is just thinking about, I don't want to pay taxes, and this is a trick. But it's not. It's just for government to have your information so that when many of these measures are being introduced, they can actually tackle them frontally and directly. We can't hear you. We can't hear you. Bukola.
The
Bukola,
microphone.
you're muted.
Your microphone, yeah.
Okay.
On mute.
You are muted, Buki.
Hey.
Buki, you are muted. You are muted. You are muted. Just click. You are muted. Just click on it. Click on your button. Just click on the button.
Maybe you should try dialing in again. I think that sometimes helps.
Yeah,
the mute button is showing. The muted button is showing that it is muted.
Yeah.
Buki, you are muted. Just click on the button. Just try it. Oh.
Okay, she's off. Anyway, the discussion. There's a point I just want to make. Can you hear me, please, gentlemen?
Well, it's only us that can hear you. The general public can't hear you.
Oh my God. Okay.
But they can hear you now.
Oh, okay.
Okay.
Just a point I want to make. Right now, we have about 40% of businesses unregistered. We have another 40% that are registered as enterprises, and less than 20% are actually limited liability companies based on the old CAMA. We want to migrate them from being unregistered and being registered as business enterprises to being registered as limited liability company. But there are institutional obstacles. The first and most important part of it is this aspect of SITA that require financial statement filing and filing of tax returns. It's been a major issue. If I may ask FIRS, how many MSMEs file financial statements every year? They're probably very negligible, and you haven't done anything about it anyway. So what is the point in having a provision and a law that people are not complying at all? It means that there is a gap, and we need to close that gap. So there needs to be an urgent harmonization of FRS requirements and the new CAMA, so that it can make sense. We are saying that we have achieved so much with the new CAMA, but FRS requirements is still tying our hands, and we can't make much progress. So we need that harmonization for us to be able to migrate many of these companies from unregistered to limited liability company. Most of the obstacles have been removed now. You can actually be a limited liability company and run your own company. And you don't have to bring in many directors. You don't have to hold AGMs. You don't even have to have auditors. And then you are still exempted from taxes. You see, the issue is this. Many of these small businesses open bank accounts, but they open bank accounts in their own name, not in any business name. And there's a problem for them because the tendency is for them to mix up their personal finances with their business finances. And so when we give them facilities or we give them loan or we give them support, it's difficult for us to separate. So if they can become limited liability company, we can be able to track all the support we are giving them. In fact, we insist that they open a bank account in their company's name, not in their personal name. So this is very important, and that's our major task going forward. Once this thing is gazetted, we have no choice but to now begin to do what we call bulk registration and migrate them from informal sector and from business enterprises to limited liability companies.
Thank you.
No, you are back. Welcome back.
Thank you. I believe one of the problems the CAMA did not solve is technology. So that's beyond that's beyond all of us. So coming to you, Mr. Debi, can you tell us how can companies identify the type of company they're dealing with at the time a service is being provided in order to determine whether to deduct withholding tax? Chinago is also asking that what action should a paying company take if it is unable to determine the type of company at the time of payment? 3, at what stage does the status of a small company change to a bigger one, and how will this fluctuation in turnover be managed if it occurs? A lot of questions.
Yeah, a lot of questions. So I only got 2. I'm not sure I got the last one. So okay. The first one is how do you determine the level of company to know the rate of withholding taxes to deduct? Well, that is still a company for withholding taxes is not graduated into level. So this was based on the service. So the question now remains that if somebody who is exempt from tax, so let's assume from somebody who is turnover less than 25, and it's really a small company, then do service to me, and the law says deduct withholding tax. Should I need to deduct withholding tax from a company that just doing 10 million turnover? Because that tax is supposed to be an advance payment or tax for him. So since it's not used to him, I should not deduct. So if the company can prove to me I'm an SME, Otumba has given me a certificate that says this company is doing less than 25 million turnover, then at that point I can say, okay, it's safe for me not to deduct withholding tax from that company. But I will always advise company to hedge on the side of caution. If a company provides service to you, it is for the service provider to prove that it's not liable to deduction and give you evidence of that. Otherwise, I will advise you go ahead and deduct. So, but withholding tax does not expire in a way. If FRA is trying to make it to expire on the day of the year of service, but if you're a small company, if you are small today, you can be big tomorrow. So, so if someone doesn't deduct withholding tax, you can still keep it. But in the essence, determining the level of service at the level of a company to determine withholding tax that can be deducted is going to be very difficult. I would just say if a company cannot prove it's a small company, then the recipient of the service should just go and deduct withholding tax at the rates indicated by law. So I think it's what I have to other question. Go ahead, please.
I think you're part of the last question anyway, and it just says at what stage does the status of a small company, right, change to a bigger one, and how will you manage, the fluctuation in your turnover if it occurs? Okay. But I mean, go on. Please.
There can only be one change. The change is when you are not liable to tax and when you now become liable to tax. Being liable to tax also have stages. When you are 25 million turnover, you are exempted. So maybe at that point you can say, I won't deduct withholding tax. Maybe the person can prove to me. So when FRS come, I can show this is the company's auditor account, the turnover is below 25 million. As a way of being exempted, so SRA can exempt me, will not penalize me. By the time a company moves to 26 million, it's no longer a question of non-deduction. And there is no exemption as to the rate or at that point. So 26 million and above, you have to deduct if the person cannot prove it. So by the time you move from really micro, as Otumba described it, to medium size liable to tax at 20%. So at that point, when you start becoming liable to tax, whether it's 20% or 30%, you are liable to tax anyway. When you become liable to tax, deduction is no longer a question of, oh, should I deduct or no? You are liable for deduction. So you don't have to manage it. If a company cannot prove that it's micro exempted from tax, then the service recipient is expected to deduct tax.
Very well said. Better to err on the side of caution.
Right.
We totally agree with you. Baba Jimmy, you know we're a very religious society. So can you tell us, how does the CAMA impact on the operation of churches in light of the powers given to the CAC under Part F?
Look, I think that when one considers the fact that these associations, right, are set up for certain specific purposes, which are more public than personal, right? I believe there's a section of CAMA that says that the assets and property, right, of these registered trustees, these associations, must be used solely towards the achievement of their objects. I also believe that there are certain tax reliefs that they enjoy because of this status, right? Because they're not commercial entities. I think that something has to be given in return. You can't enjoy that status and at the same time not want to be regulated. I think the major problem is that as a country and as a people, and you can't blame us too much about that, there's a fundamental distrust, right, of our leaders and people in government. I think the fears are that this power that has been given to the CAC may be abused. I mean, even you, Bukola, alluded to that when you talked about CAC's powers to impose fines and determine how much the fines are. So I don't think there's anything unusual about having supervisory or regulatory powers over these associations. I think the regulators, the government just need to find a way to convince these associations that the powers that they hold, and which, by the way, they had some of those powers in the previous legislation anyway, but they just need to build confidence in these associations and let them understand that these powers will not be excessively used or they will not be abused. But I doubt that one can seriously make a case for them being totally unregulated. Yeah. Thank you.
Thank you very much, Baba Jimmy. And a big thank you to our panelists. I think it's been a very insightful session. In wrapping up, I'm going to be asking you, one question each. And I'd also like you to take the opportunity to give us any last words on this webinar regarding the CAMA, the implications, and anything, which is a burning issue for you that we haven't addressed that you think will be relevant to our audience today. So I'm going to start with you, Mr. Ndia. And, just to talk about, and of course, first of all, applaud the CAC. We know a lot of support, was given by the CAC, in coming up with this new CAMA. So a big thank you to you and your colleagues, for the work that's been put in. We know, as well, we've talked about the ease of doing business, on this webinar today. And I'd like you to also tell us in wrapping up how you think the CAMA 2020 will further improve the ease of doing business in Nigeria, and just any comforting words, to all of us who are eagerly awaiting, the gazetted CAMA, and of course looking to the CAC to see how you will implement all of these things that have been thrust upon you by the CAMA 2020.
Well, thank you very much. Quickly, I think the panelists have raised a lot of issues that will be ushered in by the new act. I know we have already talked about the issue of one-man company. Another thing that is there, which is also new, is the concept of business rescue, which is a radical improvement on our insolvency practice at the moment. Apart from that, there are also issues of enhancement of protection of minority shareholders. And there are also additional disclosure requirements, which we have already alluded to, which is what we call persons with significant control that are required to give notices to the company and to the commission. So by and large, what the new act has done, apart from ease of doing business, is also to lift up the level of corporate governance to global standard. So that one we have seen in the new act. And it is expected that if we have to attract foreign investors and also enhance the status of local investors, we have to operate in line with global requirements. One thing I want to say before I quickly round off is on the issue that has been raised before now, on the need to reconcile the provision of the new act with respect to Finance Act on small companies. Now, Section 334, which deals with the issue of small companies, if that section is read carefully, you will come to understand that the provision also allows CAC not only to prescribe that particular requirement of 120 million, but it can lower that threshold. So what the Commission has done is to actually harmonize its position by way of regulation to bring it in line with what is contained in the Finance Act. So going forward, our definition of small companies will be the same with what is contained in the Financial Act, so that we don't have divergences between what Federal Inland Revenue requires and what the Commission requires. So that, in summary, is what I say as a rounding up. Thank you very much.
Thank you very much, Mr. Justin India. It's been a pleasure, tapping from your wealth of knowledge. Thank you. I'm going to go quickly to Abibat. This is a good opportunity for you to air out and tell us the specific gray areas in the CAMA that you recommend stakeholders and people need to pay attention to, so that if possible, we can get it onto the omnibus bill. So can you tell us what those things are from your perspective, and of course, any other information you would like to pass on to our audience?
Thank you very much, Bukola. Thank you very much for that. A lot has been said on this session, so from the misalignment between the definition of small companies under the new CAMA and under the Finance Act, which Mr. India has already cleared up, would be harmonized in the regulation that will be issued by the Commission, to the need to have a regulation that prescribes the penalties, specific penalties for infractions under the law, to avoid discriminatory or arbitral imposition of penalties on on companies. In addition to those that have already been said, there are at least, I think, about 2 gray areas that I've also identified from my review of the new act, from the version that I have. There is the section that exempts, okay, there's the section that exempts small companies from audit requirements. That section, the wording of that section uses the word may. So that appears to suggest that that exemption is not automatic. So it would be good to know what the Commission is thinking in line of how this will work in practice. Is the Commission looking to issue exemption certificates, or there's going to be an application process for this sort of thing? What is the Commission looking at really? Also, there are references in the Act to the disclosure of managers' remuneration at general meetings of companies. But the Act fails to define who a manager is. So will, for instance, a floor manager or a field manager be a manager for the purpose of this requirement? We don't know. I would assume that, the provision is targeted at, senior members of the senior management team, like, the CEO, the CFO, and the CEO, but there needs to be clarity, on that. Other than that, like you said, we really do applaud the legislators, the Commission, and all the consultants that were involved in drafting the new Act. I think they've done a really, really commendable job, and, we'll be looking forward to seeing what the Omnibus bill comes up with, in addressing all these gray areas and all the issues that have been already identified. Thank you, Paula.
Thank you, Abibat. Please, as a member of the public, we don't want you to just look forward to the Omnibus bill, so we don't continue to have these lengthy conversations. Please send in your comments, right, to the PEBEC, and so that all of those things can be considered, in putting the Omnibus bill together. Thank you again, Abibat. It's been a real pleasure. Lateef, over to you. I know that the new CAMA mandates every public company to now disclose their audited accounts on their websites. Would you say this is commendable? And what else do you see generally? And how would you? What parting words would you like to leave our audience with?
Yes, I'll say this is commendable, and if you look critically into the focus of one of the focuses of the new CAMA, I think a lot of thought has been given to refocusing our effort on the landscape of digital economy, and one of the many things that we have newly is the fact that e-signature is now being accepted, as one of the ways to actually append signature on document. You have virtual AGM, and of course, for the publication of financial statements on website, generally speaking, public companies that are quoted on the floor of stock exchange, have this requirement based on the NSE rule book. They're also mandated to also publish their financial statement on the website. So CAMA coming this time to have it specifically stated, in this particular act is a very commendable effort. So we then suggest that a lot of harmonization has gone in. If we also refer to Nigerian Electricity Regulatory Commission Act, it also states that licensees should also publish their financial statement on the website. So this is a very commendable effort. So this is an attempt to also harmonize with other, requirements, other statutory requirements based on industry and what have you. I think this is a very welcome, development. So I think that's my take on that aspect.
Thank you very much, Lateef. Thank you for sharing your time with us this morning. Baba Jimmy, lawyers have also complained, but some of us have also been really happy. So can you tell us, will the CAMA 2020 change the way corporate lawyers support companies in Nigeria? Some people have said that CAMA and the CSE are trying to take some food off the table of lawyers. So tell us about that, Babajimi. What's your opinion?
Okay, so for me, I think that yes, the new CAMA will help corporate lawyers to serve their clients better. I think the new law places a lot more tools at our disposal now to help our clients. I think for me, one of the best introductions into that statute is the business rescue provisions that it comes up with. I think especially now in the midst of a pandemic where a lot of companies are not doing well, where you have creditors and landlords breathing down their necks, I think the moratorium that is provided under the company administration process will be a welcome relief. And I think lawyers should actually familiarize themselves with that process, and they'll find it very useful for their clients. Now, you mentioned the issue of taking food off the table of lawyers. Unfortunately, I'm probably part of that minority of lawyers that does not agree with that. I think we spent too much time in university, too much time in law school to be focusing on just incorporation of companies. I think in other countries, you don't even need to be a lawyer. I mean, you and I know that we sit in our offices in Lagos and we actually incorporate companies in other jurisdictions, right? Online. So I think that what lawyers should do is focus on the high value aspects of CAMA and the other new revenue streams that they can generate from the introductions in CAMA, rather than on the more rudimentary aspects, which is company incorporation as far as I'm concerned. So I think there are lots more opportunities in the law. I think what we need to do is actually sit down and look at how we can harness them and, help improve our clients' businesses and then generate more revenue for ourselves. Thank you.
Thank you. Thank you very much, Babajimi. Otumba, I will come over to you. We've spoken a lot about the CAMA today. And, we will also like to hear from you. What other areas, should the government be looking at to improve the ease of doing business in Nigeria, particularly for small businesses? As we know, I mean, they are one of the really great ways we're supporting our economy these days. So what other areas should we be looking at?
Thank you very much. Let me rephrase my answer. I'm not going to answer your question. I'm going to make a comment. I highlighted in my book, The Formula for Wealth, that over 85% of small businesses in Nigeria are struggling and they are operating far below their capacities. And the main reason why this is so is because most of them are informal and they are unstructured and they lack the fundamentals of successful enterprises. Small business, and those who are listening, those who are watching, I want them to listen very carefully. Small businesses need to begin to take fundamental steps to formalize their businesses and to take advantage of numerous growth opportunities available in funding, in capacity building, in opportunities that are growing every day. Going forward, I would like to see most businesses incorporated, and the new CAMA has created that avenue. I would like to see most of them operate corporate bank accounts. So when they are incorporated, they open corporate bank accounts. I would like to see them have proper bookkeeping and prepare financial statements. Most of them don't do this. And we are explaining this every day, that they are losing out a lot. So I would like to see them do that. I would like to see them file statutory returns. Even if they are tax exempt, I would like to see them file their tax returns. Many of them are not very disciplined. Let me put it that way. Some people just find themselves doing business. They don't even know why they are there, and they don't understand that it comes with certain obligations and responsibilities. And they have to be ready to take those responsibilities. You cannot continue to complain of poverty every day, and yet opportunities are coming by, you are unable to take advantage of them. If you are not a registered business, and then there's money coming from International Finance Corporation to help small businesses, and they specify that you must be limited liability company, how can you take advantage of these opportunities? And there are so many. You can't even approach a bank to borrow money because you are informal and you are unregistered, and your business is stuck on ground, is unable to grow. So this is a major opportunity. All the complaints that we have been getting before is too expensive, it's too complex, the requirements are too stringent. Those ones are no longer going to be issues. So I would like to see many small businesses take advantage of the new CAMA, migrate from informal or just be a business enterprise or business registration and move to incorporation and begin to operate formally. That is my dream. So that's very important, because when this is done, then government policies and programs will become more effective. People will now begin to take advantage of this. You can't imagine the headache we go through. We want to help agro farmers and we want to pump money into agriculture. But 90% of them don't even have proper books. So even if you put the money there, how do you track what you have put there? You come back next year, you want to see how effective your funding has been. That is going to be very difficult for somebody to collect your money, put it in his own personal bank account, and is spending the money on the farm, and is also spending it on himself. You know, so those are the issues that are at stake. And this is a major shift, a monumental shift in the annals of businesses in Nigeria. And I want to begin to see a lot of changes for small businesses to take responsibility and change the ways they are doing business. Thank you.
Very well said, Otumba. And the beauty is that the SMEDAN is available to support all of these businesses through the process. So thank you very much. And of course, for all of you, you know, small business owners, entrepreneurs, I definitely will also recommend Otumba's book, The Formula for Wealth. Now, I'm going to turn this over to our host, none other than Mr. Adebi. What will you say to our audience as we part with them today?
I think my comment is actually more for Mr. Johnson of the CAC and the regulators. One, two things. I don't think we need to wait another 30 years to amend the Company Laws Matter Act. These things are done as business evolve from time to time. 30 years is too long. So maybe we should look at it amending in then 2 years or 3 years. Two, Mr. Johnson, sir, there is need for government to remove that requirement in Company Law Matters Act that for a company to do business in Nigeria, he has to register here. Because I'm aligning this to the requirement that's the new Finance Act that require foreign companies to pay tax in Nigeria on what they call significant economic presence. So Amazon is not here, but FRS want to start taxing Amazon, taxing Netflix, taxing Facebook. But in your book, in the law, you are still saying before you can do business in Nigeria, you have to register in Nigeria. I think that requirement, in my view, need to be amended. I mean, there is no need. You don't need to have that anymore. Anybody should be able to do business for as long as the person is willing to pay the appropriate taxes in Nigeria. And the third one and last comment I will make is that as you are aligning the turnover to be in line with the 25 million that FRA is requiring, the requirement for not having statutory audit should also be considered. So maybe you want to say for company with minimum with 25 million turnover, a small company, you don't require statutory audit. Maybe you only require financial statement, a simple financial statement to file your taxes. Because I also can't remember reading any part of the CAMA that exempt company from also filing when they find the annual return to say you don't require financial statement anymore. I don't know whether this was done because one of the requirements for filing your annual return is your audited statement. So also if as a small company you are not required to have an auditor, then you are not meeting that provision of the CAMA that require to file your annual return with your financial statement. So these are the areas that still need to be streamlined as we go along. So I would say I thank everybody for listening to us, and so I'll hand over to Buki.
Thank you very much. Thank you very much for being the voice of, you know, all of the people. So Mr. Justin, we trust that you take all of this feedback back on our behalf. A big thank you again to all of you, our panelists for today. It's been a really, really insightful session. And to our very, you know, attentive audience and participants, we say a big thank you as well. We hope we're able to answer your questions. We trust that you found this very educating. And of course, if you have further questions, please feel free to send emails. We will be more than happy to get in touch with our panelists to respond to some of your questions, which if they were not attended to. So thank you. This is one of the webinars we host in our series with Anderson Tax. We will be sure to publicize any other future webinars, and of course we hope you will join us on those webinars. Thank you and enjoy the rest of your day.